My name is Jeri Cohen, and I actually grew up in Miami. I left Miami in 1970 to go to college in Boston University, and of course I was on campus during a very interesting time in our history. There were a lot of changes for women. It was right at the end of the Vietnam War. So I was introduced to a lot of radicalism on campus, especially being in Boston, and I was very much involved in the women's movement, in abortion rights, and was an activist on campus. I then went overseas to Durham. I studied Arabic language, and I was in Durham doing part of my undergraduate work, came back to Boston and graduated, and did a master's in Arabic studies at Harvard. After that, I moved overseas. I lived in Switzerland, where I was doing doctoral work, and also in Tel Aviv. Came back to the United States in the let's see, probably the late 70s, 1980. And I worked as a lobbyist for the Union of Councils for Soviet Jews. The primary concern of that agency was to get Jews that wanted to leave the Soviet Union out. You'll remember at that time that it was right after Poland and Afghanistan. The Soviet Union was closed very tightly. And I used to go into the Soviet Union, bring in books, bring in kosher food, meet with dissidents, get chased around by the KGB, and had the privilege of working at the Robert F. Drinan Human Rights Information Center in Madrid, Spain, in connection with the Conference on Security and Cooperation in Europe, working with the dissidents' families, the refuseniks' families. So again, I was in this activist kind of mode. When I returned to Washington, and while I was working for the Union of Councils, I applied to law school at Georgetown, went to law school, and graduated in 1985, clerked for a judge, worked for the Securities Exchange Commission, had 3 children. Those children today are 24, 22, and 17. So I came back to the Miami area in 1988 and worked for Janet Reno. And I got elected to the county court in 1992, began my tenure in 93, and that was about the time that Janet Reno went to Washington to assume her position as Attorney General. Before I got on the bench, I was very involved in abortion rights and women's reproductive choice issues. We were confronted with a governor at the time who wanted to restrict the right to choose. It was a very, very activist period, and in the course of our activism on behalf of abortion rights, I started an organization called the Women's Emergency Network to fund abortion for needy women. And I'm proud to say that until today, it's a very active organization. The organization has funded thousands of abortions for poor, needy women. When I got on the bench, I had to stop the activism, and I have to tell you that my friends, my mother, were very opposed to me taking on a judicial role, because they felt that I wouldn't be able to be verbal and I wouldn't be able to be involved in the things that I had heretofore been involved in. And it was a real struggle in the beginning. But when I was elected, I was appointed to serve in the DUI division, driving under the influence. And within a year, I began to see that a lot of very sick people were coming into the court. We were not treating alcoholism as a disease, but we're treating these people as criminals. And so very soon after I got on the bench, I started a DUI court with no funding, no support at all. And keep in mind, this is back in 93, 94, before therapeutic jurisprudence was widely accepted. I remember going to Washington and talking to some of the people at, I think it was at CSAT, the Center for Substance Abuse Treatment, about alcohol, and I was told by the gentleman that was overseeing court projects that they did not consider alcohol a drug. They were funding drug courts in the felony division at the time for crack cocaine. So I went back and I started my own DUI court. I made good connections with the substance abuse facilities locally. I got the people coming in front of me to go into treatment. I got an agreement from probation to monitor them intensively. I learned as much as I could about substance abuse and mental health, how they co-occur, and worked closely with Alcoholics and Narcotics Anonymous. And what I started seeing in the courtroom was just miraculous. You know, the lawyers were opposed to it, both the public defender and the prosecutors. The prosecutors wanted to treat it criminally. They didn't want to take the time to think about treatment. The PDs just wanted their clients to get off. They didn't want scrutiny. They weren't interested in them getting better. And there was no support in the community from my colleagues or, you know, from the community at large. But I was able to secure funding from the Florida Highway and Safety Department. I can't remember what they're called. And what they funded was a DUI recidivist project that provided for intense supervision along the lines of my model for DUI offenders. So that became a court project. And subsequently, I was honored nationally by NHTSA. So, and during this time, things started changing. You know, I'd say that it was probably the mid to late 90s where you really started seeing therapeutic jurisprudence catching on. In 96, I was elected to the circuit court, and I came immediately over to dependency. And I began seeing the same kind of progression, same kind of really ignorance that I had observed in the county court. Primarily an inability to understand the disease or the addiction model of substance abuse, and in a lack of understanding of co-occurrence. We know that 75% of the people that come into our court have co-occurring mental health and substance abuse. The lack of knowledge about how trauma interacts with all of this, especially with women. And what we were seeing here is that that a woman would have a substance-exposed newborn. We'd provide services through our dependency court. There'd be no follow-up, no real integration with the substance abuse providers, no integration with the providers that were treating the families at the children and family centers that dealt with substance abuse newborns. And we were basically monitoring the parent for 6 months. If their urine was clean, we were returning the child. Now, a lot of these parents couldn't get their children back because we weren't using a holistic approach to treatment. We were not recognizing what the barriers were to recovery. But the mothers that were getting their children back, they'd be back within a year with a subsequent substance-exposed newborn. What we were seeing is about 80% coming back through the system. And ultimately, these women were losing their children. So what I did was I went to the legislature, outside of my court structure, which you're not supposed to do, and I obtained funding for addiction specialists to be attached to my court. And at that time, I'd say there were about 8 dependency, child abuse and neglect drug courts in the country. We were one of the original ones in that group, and just started piecing together a holistic approach to these cases. I'd say that, you know, substance abuse motivates our system. Without it, we'd have very few cases in our dependency system, and we just were not being smart about treating because we weren't following the science and we weren't looking at what we knew. And most importantly, our treatment facilities were not using best practices or evidence-based treatment. Their treatment was not gender specific, it was not holistic, it did not take co-occurring disorder into account, and it did not take trauma into account.